Yes, the three-judge bench that was created by Deputy Chief Justice Philomena Mwilu has refused to recuse themselves from the impeachment motion of Rigathi Gachagua. We all know that Rigathi Gachagua's lawyers had requested the judiciary to recuse these three bench judges, and they put up a fight. They asked these judges to run away from this judgment. You know, in law, you can ask a judge who's presiding over your case to recuse himself if you don't trust him or her, but you should give the reasons. And this is why the lawyers of Deputy President Rigathi Gachagua did this, but the judges refused. So in this episode, I've come to talk about why the judges refused to recuse themselves and what effect it can have, but most importantly, the study materials we can learn from the politics of our nation. But before I do this, I want to know that if you're new to this channel, please subscribe. If geopolitics and economics is what you want, this will be definitely the right channel for you to subscribe to. So we all know that Deputy President Rigathi Gachagua reigned in the courts of law when he was impeached. And even the way how this bench was made, it was not rare for a Deputy Chief Justice to form a three-bench judge. Even me, I thought that it is a preserve of the Chief Justice alone, and that is Martha Koome. Although my depth in matters of law is not so big, so maybe they are right or wrong. But the lawyers of Rigathi Gachagua went to court and even vowed to appeal this decision. In fact, by the judge refusing to recuse themselves, it is a sign of it is a sign which does not look good, because if I don't want you to be a judge in my matter, it is only better for you to recuse yourself. This is what is done in big democracies. That is the truth. In case you give out a judgment that is against me, I can use that platform, okay, to decampaign you as a bad judge, because I had shown interest of you recusing yourself from the case before you give out the judgment. So I think some of the judges who were called to recuse themselves, the best thing was to recuse themselves. In fact, the lawyer who asked this went on an extra mile to explain. Let me play your videos. Some are long, but let me play your video when he was talking this.
Out. Justice Murima should be out. My lady judge, may I say, I'm letting you, I'm not discriminating against you. I'm one who has fought for rights of women, and I kept on shouting very loudly that we want women judges. I have not had the fortune of appearing before you very often.
Actually, you have on a couple of times.
Oh, sorry. My memory is letting me down because of it. Yes. But my lords, may I say, I have had the opportunity of appearing before you. And may I say this, my lords, if you go and check Judicial Service Commission records, you will not find a single letter from John Khaminwa complaining against any judge. I have never done such a thing at all. It's because I've got confidence in our judges. I've got confidence in our magistrate that they deliver justice. But I'm just saying you, my lords and my lady, if at this time we have some people who feel very strongly because that they may not get justice before you at all, please walk out. Don't continue to hear the case. And indeed, the people who are saying that your lordships or my lady should not hear this case, when they are speaking, you cannot really criticize them. They have got some valid complaints. My lords, United States of America, which I had the opportunity and the privilege of getting and studying their jurisprudence, they gave me additional legal education. United States of America, which has an impeachment provisions like Kenya, for 200 years, there is no precedent or deputy president.
That is Kamwina. He made a clear example. So there is no use for a judge retaining himself on the bench when one of the parties involved is complaining. And remember, they are not the only judges. The evidence that was put out, I know it doesn't hold water, and even me deep in my heart, I think they may have a point. Basically, 2 points. One, they may not have faith in the judges, but also it will make them buy more time, because I know this case might drag in course for a very long period of time. Okay, but if you're a judge, you don't give them that luxury. You can recuse yourself so that a new judges can be brought on board. Although if they are recused, it can also have a ripple effect. One, it sets a precedent that a deputy chief justice cannot put up a 3-bench judge. It also pokes holes in the credibility of the judiciary, saying that maybe a chief justice wanted to do something fishy. So I think this bench is going to be held in avoidance of poking a hole in the judiciary. Okay? But the best thing for me, I think it would be for the judges to recuse themselves. Because if you stick on a matter, it makes it even look more fishy. You are not the only judge who can pretend over these things. Okay? So the best thing for these judges was to recuse themselves. But since they decided to maintain themselves in the course, it will have a ripple effect. Of course, that's my opinion. Do make comments by commenting about this. Thank you very much for listening in. If this is your first time on the YouTube channel, I implore you to subscribe, like, and comment so that I can be motivated to do more of such videos. I'm going to leave you with a judgment when these judges were ruling that they are not going to recuse themselves. Here's the tape.
The legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial functions and in the administration of the judiciary as an arm of government, but cannot do so in respect of the affairs of the JSC. Our attention has also been drawn to the provisions of Article 259, sub-Article 3b of the Constitution, which states as follows. This refers to construing the Constitution, and sub-Article 3 provides as follows. Every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, be any reference in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing the functions of the office at any particular time. Emphasis, or otherwise performing the functions of the office at any particular time. The above provision creates 3 tiers in which constitutional functions can be exercised. That is, by the substantive office holder, or by a person in an acting capacity, or by a person otherwise performing the functions of the office at any particular time. In our understanding, and against the background of the doctrine as stated, the drafters of our Constitution were deliberate about ensuring that the administration of duties and the application of the constitutional provisions are continuous and seamless, recognizing the necessity for offices and their functions to be performed even in transitional or extraordinary circumstances. Such an interpretation avoids technicalities and vacuums that could disrupt the functioning of said offices or public institutions, thereby promoting administrative efficiency and upholding the principles of constitutional governance. The provision reflects the broader principles of the rule of law and good governance, which require that state and public offices continue to function effectively, even during periods of transition or when the substantive office holder is unavailable. It in turn promotes legal certainty and administrative efficiency by ensuring that all constitutional responsibilities are carried out without disruption. For this reason, the functions of Article 165, sub-Article 4, in our view, and in as far as the same relate to the office of the Chief Justice, also includes the Deputy Chief Justice acting in the capacity of the office of the Chief Justice or discharging its functions in an interim, acting or auxiliary role. At this point in time, we also wish to point out that the Honorable Chief Justice empaneled this very bench on the 14th day of October 2024 to deal with 6 constitutional petitions that inter alia challenged the first petitioner's impeachment process in the National Assembly. The said petitions are still current. On the 18th of October 2024, the Honorable DCJ empaneled the same bench to deal with constitutional petitions challenging the impeachment of the first petitioner in the Senate. To us, it is beyond peradventure that the Honorable DCJ can assign judges under Article 165, sub-Article 4 of the Constitution, whenever he or she is discharging any of the constitutional functions on behalf of the Chief Justice. In this case, we do not find any fault in the Honorable DCJ assigning judges to sit in this bench, more so when the Honorable Chief Justice has not raised any red flag. Thank you.
Right.